Hello and welcome to Devil's Advocate. How does the UPA government view decriminalization of homosexual relations between consenting adults? That's the key and critical issue I shall discuss in a moment with the Law Minister, Veerappa Moily. Mr. Moily, let's start with the Delhi High Court's judgment decriminalizing homosexual relations between consenting adults. Why is your government finding it so difficult to decide whether you accept the ruling or whether you want to appeal against it?
No, we are not uncomfortable with any ruling of any judgment, whether negative or positive. We take any ruling in a right perspective. We need to examine it. Now the matter is pending before the Supreme Court. We are here to assist the court to arrive at right decision. That is the role government will play.
Let me try and understand your thinking. The Delhi High Court in its judgment says Section 377 of the Indian Penal Code, insofar as it criminalizes consensual sexual acts of adults in private, is violative of Articles 14, 15 and 21 of the Constitution. Do you agree with that interpretation of the Constitution?
I don't think I can give a value judgment on that judgment. The question is that, there are, it's a pre-1950 law.
1860.
1860. And many a time, you evolve a Constitution of India. Then, this is one defect we have. I'm not referring to Section 377 alone. There are many laws enacted earlier to the Constitution coming into existence, where many a time letter and spirit of that Constitution may not be in consonance with many of the acts.
Well, that is precisely what the Delhi High Court says. I'm not asking you to give me a value judgment. I'm simply asking you if, as Law Minister, you agree with the Delhi High Court's interpretation of the Constitution. Yes or no?
I don't think that you can get a cut and dry reply on the matter like this, because after all, it has to be adjudicated by Supreme Court. If I say yes or no, maybe that, I will be prejudging the issue which is before the Supreme Court.
In other words, until the Supreme Court decides that it agrees, you won't decide whether you agree. You're saying your view is dependent on the Supreme Court.
No, not exactly. We may have a view, but at the same time, we have to submit that view to the Supreme Court as an assistance to arrive at a decision.
But you are also a minister. The people of India have a right to know the view of their own government. That's why they've elected you. If you have a view, and you say you have a view, what is your view? Is the Delhi High Court's interpretation of the Constitution correct?
During the pendency of a case, we don't give a personal view, because after all, it is ultimately the government view. The ministers, some of us, Mr. Chidambaram, myself and Ghulam Nabi Azad, twice we met. Then ultimately we decided that we'll have to present the facts to the cabinet.
Let me put it like this. On the 21st of July, the Attorney General of India said to the Supreme Court that the government of India did not want a stay of the Delhi High Court judgment. How should we, the people of India, interpret that?
No, it's an important question of law, particularly relating to the constitutional provision of the liberty, privacy. They are given a judgment. As against that, obtaining a stay may be sometime preposterous unless we have a final verdict from the Supreme Court.
So, in other words, to have sought a stay before a final verdict from the Supreme Court would have been preposterous.
Yeah.
So, in other words, you're also saying that if the Supreme Court decides that the Delhi High Court judgment is correct, you will not take any steps to change the law and reverse the judgment.
There are occasions and occasions when the government will not seek to reverse a judgment. We allow the things because, even the Supreme Court or the judiciary will have a right to lay down the law under Article 141 of the Constitution of India.
Is this such an occasion that the Supreme Court has a right to lay down the law?
Because even if you don't take a proactive role or a negative role in a matter like this, sometimes the court can lay down the law. But one thing is very certain, that the Delhi High Court has not abrogated or repealed Section 377.
Absolutely. They have simply read it
only
down
to a limited extent. And we have seen all through the, right from 1860, I think a matter like this, the offence like this, not even a single conviction has taken place in the country.
Those are 2 points that I concede. Let's therefore set them aside. Let's come back to the first issue that you were talking about. You're saying to me that as law minister and as a member of the government, you concede the right to the courts to lay down the law in certain areas.
Yeah, very much. How can we deny it?
Is the decriminalization of homosexual relations between consenting adults one such area?
That it is too early to prejudge the issue because the matter is already sub judice and it's before the Supreme Court.
No, absolutely.
This is too early
I'm not asking you to comment on the judgment.
Yeah.
I'm simply saying, is this one area where you concede that the courts have a right to lay down the law?
I can't say that.
Why can't you say that?
Because the individual opinion will not count, when there is a cabinet, when there is a government, individual opinion do not count.
So you're also saying to me that on several important issues, the government hasn't made up its mind. You haven't made up your mind.
No. That's it. We make a domestic exercise on that. We discuss about it. That discussion is not complete in the cabinet.
Absolutely, which is why I'm underlining it, that on two critical areas, the government hasn't made up its mind. You haven't made up your mind whether the Delhi High Court's interpretation of the Constitution is one that you agree with. You're waiting for the Supreme Court to determine the matter.
And also the cabinet to take
and the cabinet.
This, yes.
So both the Supreme Court and the cabinet will decide the government's opinion. Therefore, on this issue, the government hasn't made up its mind.
Yeah.
And the second area where you haven't made up your mind is whether decriminalization of homosexual relations with consenting adults is an area where the courts can lay down the law. Again, the cabinet has to take a decision.
I have told you the general approach to the question that, many a time, the government, there are instances and instances when the government will not make a law, will not provide a law. That is what is happening.
You're giving me a
and that can be governed, but already section 377 is an all embracing, all comprehensive instrument by which many of these offences can be punished.
You've given me a very important hint. You said
because what is punishable is private.
Absolutely.
Nobody knows. What is not punishable is private according to the judgment. What is punishable if they indulge into it in public.
Quite right. But you said something very important. You said that there are areas where the government does not feel a need to lay down the law.
Yeah.
There are areas where, in fact, the courts can take over and lay down the law. You're hinting. You're not saying it openly, but you're hinting.
That is the fact of the matter. That is the law of the land.
Yes, but you're hinting here, aren't you, that you may be happy to live with the reading down of Section 377.
As a law minister, I'm very precise, very clear. I don't want to be vague on these matters because, after all, when I speak, I speak as a law minister of the country.
But you're still giving that hint, despite this qualification.
It is not. It's a matter of fact. That is the law of the land.
It's a matter of fact. It is the law of the land.
Yeah, very much so.
That will be interpreted as confirmation of the hint.
No, I'm not. Normally, we don't give room for inference, presumptions from out our statement.
Let me put it like this.
I think I'm very clear.
Let me put it like this.
Yeah.
Do you believe that the activities that adults get up to, consenting adults, in the privacy of their home, should be criminal or not?
That's what the Delhi High Court said. It is not criminal.
What do you believe?
No, there's no. I would have given you as Mr. Moily, as an advocate.
Give me the answer.
But I can't give you because I represent the government. I'm the law minister of the country.
Let me put it like this.
I don't want to prejudge the issue when the matter is before the Supreme Court and the matter is before the cabinet.
This is an issue that goes beyond just prejudging. It touches on the nature of what sort of democracy India is. India is proud to be a liberal democracy.
Yeah.
Is it acceptable that we are also perhaps the only major liberal democracy in the world where what consenting adults do in private in their bedroom is considered possibly criminal? Are you happy with that?
That is why not even one case resulted in conviction.
But the law is still there.
Because after all, law sometimes, cannot reach out to beyond a distance. This may be one of the cases, when law cannot reach out its hand beyond a distance. But still, that law is in the statute, maybe ineffective, maybe would have been frustrated.
You said a very important thing.
That's a different matter.
You said a very important thing.
Yeah.
The law has not been used, but bad laws are capable of misuse, which is why they shouldn't exist. Secondly, bad laws brand and victimize people, and that's not right in a democracy. Therefore, even if the law is not used...
Any law, should not be used as an instrument of exploitation, harassment, or allow the authority to misuse it. This is one such provision which has a tendency of misuse and exploitation. I do agree on that ground.
So on that grounds, should it be removed or amended?
No, you are asking me to give a judgment on morality and immorality of the things. You know, as far as the law is concerned, it doesn't lay down, it doesn't discuss or deliberate on the morality or immorality anymore.
Absolutely, but
this
you
is
said
one such area where, you know, I don't want to give a speech
but you said
on morality.
Before I take the break, I want you to reiterate a very important thing you said, that this is one law that is capable of being misused.
I agree with you. It has been misused.
It has been misused.
It's a matter of fact.
And as long as it exists, it is capable of being misused in the future as well.
Possible. Possible. If it has been misused earlier, it is capable of being misused in future also.
And no good government, no sensible government can allow a law to exist which is capable of misuse. At least that's a good reason for thinking very hard about it.
That's why the judgment was given.
Let's take a break at that point. I want to come back and approach this matter not in terms of constitutional legality, not in terms of the government's decision, but in terms of the clash between the rights of individuals and what is called public morality, or the tradition and culture of the country. That's in a moment's time. See you after the break. Welcome back to Devil's Advocate with the Law Minister, Veerappa Moily. Minister, let's not talk about the Constitution specifically, although clearly this is a matter of constitutional law. Let's approach this matter of the decriminalization of homosexual relations between consenting adults in a slightly different way. On the one hand, you have an issue that concerns the rights and liberties of a section of the population. On the other hand, there are people who say that this infringes on public morality, it infringes on Indian culture and tradition. Which do you think should be more important, the Constitution and the rights and liberties of people, or public morality and tradition and culture?
There, you have to make a distinction between the public morality and also the morality of a person. When it comes to the public morality, yes, laws do subscribe to this. When it could be a personal morality, laws may not subscribe to it.
Are you therefore saying that laws that affect the rights of individuals, particularly when those individuals are not doing any harm to anyone else, then the personal morality must subscribe to the Constitution?
I must tell you that we have a Constitution. Many a time the Constitution runs parallel to the provisions of many laws which was enacted earlier to the Constitution coming into force.
In other words, laws that predate independence.
Yeah, very much, very much. That's why many of these provisions, you put many of the provisions of those laws, including some of the sections under the IPC or the Evidence Act. Many of these things, maybe that many of them, if they are put to the test, acid test of the Constitution, they may not stand up to the scrutiny of the Constitution. This is the apprehension. Maybe that either the Constitution makers or thereafter, I think there should have been a proper review of all these laws, so that either the laws are changed or the Constitution would have been changed, so that there would have been a proper synchronization of the laws of the land and also the Constitution.
You've said two very important things, and I'm going to repeat them for the audience, and I want you to confirm them. First, you're saying that there are many laws that exist today which are part of the penal code, which predate independence and may conflict with the principles and rights given to Indian citizens by the Constitution. And there is therefore a need to amend those laws in the light of the Constitution.
I'm telling you, putting both things together. If you want those laws, which may be struck down or put to the test, either you amend those laws or repeal those laws, or if you are very particular that those laws must find the strength of the Constitution of India, then maybe that we may have to amend the Constitution.
So either amend the laws or repeal the laws, or amend and change the Constitution.
Correct.
But you can't allow this dichotomy, this contradiction to continue.
That environment of dichotomy between the laws and the Constitution is very much manifest. That is how, Constitution of India, which is supposed to be the conflict resolution document, is being transformed into the conflict generating document because of the conflict of opinion or the conflict of provisions in the laws.
And you also said a second important thing. You wish that this synchronization, as you called it, had been done by the constitution makers themselves.
Yeah.
It shouldn't have been left to later generations.
Very much so.
Let me put something to you. The Delhi High Court in its judgment extensively quoted from Jawaharlal Nehru's speech to the Constituent Assembly in 1946 when he said that people who are considered different or deviant must not be ostracized or excluded on those grounds. Does your government agree with Jawaharlal Nehru's views?
Absolutely. He is the real founder of the Constitution of India. And he is the real founder of the ethos of liberalism in the country. And I must tell you that the constitutional makers should have seen to that. But many a time, some of these wishes of the constitutional founders have not been transformed into the laws of this country.
That I understand. But you said a very important thing. You completely and totally as the government agree with Jawaharlal Nehru's views.
Very much so. But I must tell you,
I'm just repeating it, that people who are different or are considered deviant must not be excluded or ostracized on that count. You agree with that?
No, the law should be gender neutral.
Gender neutral.
Yeah. And this is the principle of law.
One other thing.
And there cannot be discrimination. I don't say by that that I'm giving a judgment on this.
I understand. One other thing.
But one thing must go to the credit of the Delhi High Court judgment. That means a well documented, well researched. I think I must tell the judges subject may be different, but at the same time this is one judgment which has really stand out in the judicial annals of this country.
Well researched, would you also say
well documented, well argued?
Well argued.
And,
well argued. Yeah. If it's well argued, then you agree with the argument.
You present an argument before the court. Even if you well argue, you may lose the case.
I won't trap you. I won't trap you. But I think there's a clear hint there. I can't trap you. You're a minister. You have to abide by the collective decision of the government. But you've just given a hint. If it's well argued, you must agree with the argument. My last question to you. Are there any differences in the government over this issue of decriminalizing homosexual relations between consenting adults?
In fact, the Prime Minister, Dr. Manmohan Singh, asked the Home Minister, the Law Minister, and also the Health Minister to discuss and deliberate on these matters. Even earlier to the judgment, we were directed because Health Ministry took a different decision than the previous Health Ministry. And that is how they wanted that we have to deliberate on that.
So today's Health Ministry has taken a different view compared to the Health Ministry under Mr. Ramadas.
That I can't, share with you that secret.
But you hinted at it just now.
No, I can't do that.
Are the three of you of one mind?
One mind in formulating the presentation and giving it to the cabinet.
What about one mind over the issue of decriminalization?
No. One mind, analyzing the judgment.
Okay. You're hinting once again at differences, but I won't embarrass you by pushing it further. You can't reveal more. A pleasure talking to you.
Thank you.
Mr. Moily.
Thank you.